Hi, I'm attorney Skip Reynolds with Skipton Law Estate Planning and Elder Law here in Centennial, Colorado. And on today's video, I want to talk about just having a financial, or what we call sometimes a general power of attorney, and how just having that document may not be enough. So one of the things that we run into quite often in our office is people have done things on their own, meaning they've gone out to a resource online, maybe they went to a local store, bought what they called a power of attorney. Then they go through it, then they sign it. Maybe they sign it right, maybe they sign it wrong, maybe they sign it with the witnesses, maybe they sign it with just a notary, whatever it might be. But one of the things that we found is just having that document doesn't necessarily mean that that document's going to work the way you thought. So oftentimes what happens is we do this thing because we know we need to do a power of attorney. We've been told we need to do one. And so we go out and we find this resource for free or close to free because we know we need to do it. And then we go through it, and on the Colorado statutory form power of attorney, there's a whole bunch of places where you need to initial if you want to give those powers. The issue with this is there's a whole page where if you do not initial, you have not granted these powers. So you have to go through line by line by line and initial. And one of the things that I think is happening here is, just like so many other things in our financial world, if we don't understand it, we are less inclined, especially when it has to do with our money, to give any power regarding it. And these powers that are not being initialed by clients are not giving powers to their family that they may have wanted to give had they understood what it was at the time that they signed the document. So what keeps happening in our office is a person has a power of attorney. Maybe it's newer, maybe it's older, doesn't really matter. But it hasn't empowered their power of attorney agent, the person they chose to handle their affairs when they can't, hasn't given them the authorities to do many things. And it can cross a whole range of different ideas. I mean, it could be we wanted to fulfill dad's wish of avoiding probate, but we can't go and do any beneficiary designations because that power wasn't given. Or we wanted to deal with the real estate to try to avoid probate, but we can't do any beneficiary designations, nor can we create any type of trust, and mom or dad hasn't created a trust prior to their incapacity. Or maybe we're trying to continue gifting to kids, grandkids, or maybe we're trying to do gifting strategies to protect assets because of Medicaid issues going on for that individual. And one of the ones that we've seen here recently, we've seen, I think, 9 different circumstances in the last 12 months, is somebody was qualified for Medicaid, their family was applying for long-term care Medicaid for them, and they were being denied that Medicaid because a power to create a specific type of trust that would be necessary if your income is slightly too high wasn't granted by the power of attorney document. So therefore, when it was reviewed by the state on that Medicaid application, the state denies the Medicaid, saying, you don't have the capability to create the trust necessary for the extra income. And in one of these circumstances, it cost the client's daughter thousands and thousands of dollars to back pay for the nursing home costs after the denial, in addition to other things that they had to pay for mom until things got settled. So just having that power of attorney doesn't mean you can do whatever you think you need to do. The powers must be granted within it. And if the powers aren't granted within it, I don't care if you have the document or not, there could be problems that you run into. Whether it be Medicaid related, which is what we see a lot in our office, it could be tax related. It could be how to avoid probate related, or fulfilling other wishes that may have been stated by the individual prior to their incapacity. If you don't have the certain things initialed, you will not have the power. So just having the document may not be enough. So be aware, if you have a power of attorney, if it's older, if it's in particular before 2010, or even if it's more recent and you did it on your own, you may have the document, but you may not have the powers you really wanted to give inside it. If you like this content, you can find more of this type of content on our YouTube channel. You can click like, or you can become a subscriber so that when we put out new content, you'll get pings so that you can watch that new content. I also want to let you know that here in our office in Colorado, we do bi-monthly workshops where we're talking about all of the things relating to estate planning and elder law. We're talking about powers of attorney like today. We're talking about medical powers of attorney. We're talking about wills, trusts, how to protect our assets proactively or reactively in the event of a long-term care scenario, how to protect our assets for our family after we're gone. If you'd like to listen to some of that content or get involved in our process, there's two ways that you can do it. You can go to our website, which is www.skiptonlaw.com, and then you can click on the workshops tab, and then you can sign up right there. Or if you want to do it the more traditional way, you can call our office at 720-440-2774, and we can help you out that way as well. Hopefully you like this content. Please look for more content and have a great day.